Hi, thanks for tuning in to this brief overview of the Violence Against Women Act and its requirements for COC-funded programs. This training session is hosted by the Center for Housing Solutions, the COC collaborative applicant for the Away Home for Tulsa COC. So we'll start with, what is the Violence Against Women Act, or VAWA? VAWA is a landmark legislation that was first passed in 1994 and has been reauthorized subsequently several times. And its premise is that it recognizes DV as an epidemic, and it provides funding for communities and programs to respond to domestic violence. It also created a special Department of Justice Office on Violence Against Women. With each of the reauthorizations, VAWA has grown stronger and more inclusive. So some of the added protections that were included in reauthorizations extended the protection of VAWA to Native, immigrant, and LGBTQ survivors. Today, specifically, we'll be talking about VAWA requirements and protections for survivors in HUD-funded programs. And one important thing to note before we dive into the material is that despite what the name would have you believe, VAWA protections actually apply to all genders. So VAWA has a super broad and inclusive definition of violence, and it provides protection for survivors of domestic violence, dating violence, sexual assault, and stalking. And the rule includes definitions of each of these. So just to run quickly through those definitions, VAWA describes domestic violence as crimes of violence committed by a current or former spouse or intimate partner, or by someone with whom the survivor shares a child. Dating violence is similarly defined as that perpetrated by someone who's been in a social relationship of a romantic or intimate nature with the survivor, either presently or in the past. And a romantic and intimate relationship is determined by the length and type of the relationship and the frequency of interaction. VAWA defines sexual assault as any non-consensual act that is impermissible by law. And finally, stalking is defined as conduct that's aimed at a person that would cause that person to fear for their safety or the safety of others, or would cause them to suffer substantial emotional distress. And for purposes of this training, we're going to be using the term DV survivor super broadly, and we're going to be using it to refer to anyone who has survived domestic violence, dating violence, sexual assault, or stalking. So to get into how VAWA interacts with the Away Home for Tulsa services standards, we're going to cover the requirements for COC-funded programs, specifically the required notices and contract terms that COC-funded programs must incorporate. So there are a few forms that VAWA requires that COC-funded permanent supportive housing, rapid rehousing, and transitional housing provide to each household. Specifically, that's the Notice of Occupancy Rights and the Certification Form. And these two items have to be provided to each household at several different points in time. So at the very beginning, the forms have to be provided even if the household is denied assistance to your program. So say someone doesn't pass the eligibility requirements, you'd still have to provide them with these two forms. Alternatively, if they're admitted into the program and you're enrolled to the household, they also have to be provided the two forms. Down the line, if the household receives a notification of eviction, either from the program in a leasing-based situation or from the landlord in a tenant-based rental assistance situation, the household has to receive these two forms again. And finally, they also have to receive these forms if the program is going to terminate their assistance. So if you're notifying them that their assistance is going to be terminated, these forms have to be provided. And the goals is really to protect the rights of the survivors that are afforded by VAWA. And since it's difficult to identify and impossible to predict when domestic violence might occur, grantees have to provide each individual or family these forms at each of these points in time to make sure that their rights under VAWA are protected and that the family is on notice about their rights. So to that effect, the notice explains VAWA protections, including the right to confidentiality and the limitations of VAWA protections as well. And the certification form is something that the survivor has to complete to document an incident of domestic violence. So there are template forms that HUD recommends, and these are available if you email Homebase or you email the Center for Housing Solutions, and we can get you those template forms that are required to comply with VAWA. Something important to note is that the certification form has to be approved by HUD and has to provide space for the applicant to state that they're a survivor, that the incident that is the ground for protection meets VAWA definitions, and if it's safe to provide the name of the individual who committed the violent act. And again, these forms are available to you if you reach out. Now I'll get into the required contract terms that VAWA requires for COC funded programs. So there are certain terms that have to be added to various types of contracts. If your program, if you're a COC recipient and your agency has a contract between you and the landlord, any of these contracts have to include certain VAWA terms, and we'll get into what those are in just a minute. And I will note that there's some variation depending on whether your program provides tenant-based rental assistance or another type of financial assistance. There are also required terms for any contracts between property owners and participants. So the standard lease here, that's what we're talking about. So there are terms that are required to be added to those leases. And finally, VAWA also requires some terms be added to any contracts that agencies have with program participants. So if your participants sign some sort of program agreement, these terms have to be included in that agreement. And again, here there are also a few variations that we'll get into depending on whether the program provides tenant-based rental assistance, or TBRA for short, or another type of financial assistance. And you'll see that these terms are all pretty similar. They are aimed to protect the survivor's lease or participation in the program from being terminated based on domestic violence. So starting with the requirements for contracts between COC recipient agencies and landlords. These provisions are required for all contracts between property owners and agencies to ensure that a landlord is complying with VAWA in any of their leases with program participants. So basically, this says, hey landlord, any lease that you have with your tenant that's a participant in my program has to include these terms. It passes on those VAWA responsibilities to the property owner. And essentially what those requirements are is to indicate that the owner or landlord will comply with VAWA, and that any lease that they have with one of your program participants protects their rights and puts the program participant on notice and the landlord on notice that the tenant or program participant can't be denied or terminated assistance from your program or evicted from housing due to domestic violence. And it also must indicate that domestic violence against that person can't be grounds for claiming that they violated their lease. It can, but doesn't have to specify that these VAWA protections only apply during the period that the person's enrolled in the COC program. So basically, the goal here is to put the landlord on notice about VAWA rights that are afforded to tenants, and to let them know that there are certain requirements that must be met in their agreements with the tenants. And this is where we get into some of the modifications depending on program type. So when grant funds are used for tenant-based rental assistance, so you have a program that provides tenant-based rental assistance, then your agency must ensure that the owner or manager of the housing provides that notice and certification form that we just talked about to the participant with any notice of eviction. Because as you remember, one of the points at which those notices and forms must be provided is if the landlord moves to evict. So basically, if your program has an agreement with a property owner, you have to let them know that they must provide those forms to the tenant if they move to evict. And the agreement that you would have with the landlord also has to include a confidentiality clause. So the landlord has to be on notice that you, as the agency, are bound by VAWA to keep in strict confidence any information provided by the participant. So if there's a domestic violence incident that occurs, the landlord does not have a right to know about that. So the client might make an emergency transfer request, and you as the program are bound by VAWA to keep that in strict confidence, and you won't be able to let the landlord know that domestic violence occurred in order to protect the client's confidentiality. If your program provides assistance, financial assistance that's not tenant-based rental assistance, so say that you have a leasing-based program and you master lease units from a property owner, and then you have occupancy agreements with your clients. In that case, your agreement with the landlord must put them on notice that any occupancy agreement or any agreement that you as the program have with a participant will allow the participant to terminate without penalty if they qualify for an emergency transfer. Now we'll get into the required terms for leases between landlords and participants. So you'll see this is pretty parallel to what we just talked about. And there are a few terms that have to be included, and they're basically the same. It's the landlord will comply with VAWA, and again, the participant or tenant can't be evicted due to their status of as survivors or due to criminal DV acts committed against them, and that DV can't be grounds for claiming that the participant has engaged in a repeated or serious violation of the lease. Once again, the lease may specify that these protections only apply while the individual is being assisted under the COC program. And finally, similarly to the last couple of slides, there are requirements for any agreements that the program has with the client. So if there's a program participation agreement that the client's signing, then these terms, which will start to look pretty familiar, have to be included in that agreement. So these terms, again, require the agency, in this case, to comply with VAWA and put the participant on notice that they can't be denied or terminated assistance or evicted from their housing due to domestic violence, and that domestic violence against them can't be grounds for claiming they've violated their lease. Finally, and once again, the terms can specify that the protections only apply while the participant is in the COC program. And in this instance, there's again a slight variation if the program provides assistance other than tenant-based rental assistance. So if you have a leasing-based program, then you also have to include that the program participant can terminate their agreement without penalty if they qualify for an emergency transfer. All of these required terms and notices are covered in the Away Home for Tulsa Services Standards on pages 87 and 88 and 89. So if you want to revisit them, they're listed in the standards at pages 87 through 89. Finally, a couple takeaways that are super important to note. The VAWA rule went into effect and requires that these terms that we just went over be incorporated not only into any new contracts, leases, subleases, or occupancy agreements that are entered into, but also any that are renewing, including those renewing automatically. So say that you have a program participant in a COC funded program that had a lease, and the lease didn't include, the first 1-year lease did not include the VAWA terms, and now it's renewing automatically and it's going month to month and they're not signing anything new, right? You actually still have to incorporate these terms. So this can be done via a VAWA addendum. And that, again, is a form that if you want to reach out to Housing Solutions or to Homebase, we can provide you with a template contract, a template lease addendum to comply with VAWA. Now I want to get into emergency transfers, and emergency transfers are covered in the services standards at pages 53 and 54. And this is a way for domestic violence survivors to get out of an unsafe situation and to access safe housing. There are a few terms that are important to note here. The emergency transfer plan is the process for survivors that are receiving rental assistance or leasing assistance through the COC program to be transferred to safe housing. And there are two types of emergency transfers, the internal and the external transfer. So an internal transfer is where the tenant's relocated to another unit where they wouldn't be a new applicant. So for example, if the program participant is being transferred to another unit within your same program, or if they're being transferred across programs with the same eligibility requirements. So in this case, if they don't have to reapply for the program, it's an internal transfer. An external transfer, on the other hand, is one where the participant or the tenant is being relocated to a unit where they have to be considered a new applicant. So if they have to undergo a new application to reside in the new unit. And finally, a safe unit, the definition of a safe unit is pretty client-centric. It's any unit that the survivor believes is safe. So starting with the qualifications for an emergency transfer, a client of a COC funded program qualifies for an emergency transfer if they're a survivor of DV, if they expressly request the transfer, and they either reasonably believe that there's a threat of imminent harm, or if they're a survivor of sexual assault that occurred on the premises within the past 90 days before they request the transfer. The emergency transfer process doesn't require much documentation, and basically, in order to start the transfer process, the participant has to submit a request to program staff. So this has to be documented in a written way, but basically they can come in and say, hey, I need an emergency transfer, and then they would have to sign that certification form, you know, the one that you've handed them at all those different points in time, to certify that they meet the transfer qualification requirements. So that certification form is actually all that they have to sign to submit the written request to the program. There's no additional documentation that's required of the occurrence of the event. And at this point, the program that's receiving this request has to communicate with the coordination center to let them know that a transfer request has been made, and an emergency transfer request has been made, and to let them know whether the request is for an internal transfer, an external transfer, or both. So even if the client is only requesting an internal transfer that doesn't involve coordinated entry, you still have to let the coordination center know by the requirements of VAWA. A participant can seek an internal and external transfer at the same time. So a little more on the differences between internal and external transfers. So an internal transfer is one where the participant requests moving to a safe unit, and the program takes steps to immediately transfer them if one is available. And these requests for emergency internal transfer have to receive at least the same priority as any other transfer requests that the program receives. And if there's not a safe unit that's immediately available in your program, then the program has to let the participant know that they have a few options. They can wait for a safe unit to become available for an internal transfer within your agency, or they can request an external emergency transfer to be facilitated through coordinated entry to another program, say outside your agency. Or they can pursue both an internal and external transfer to get the next available safe unit in the COC. So that gets us to an external transfer, and someone who's requesting an external emergency transfer has priority over all other applicants for COC funded assistance. So they go straight to the top of the by name list, and they still have to meet all eligibility criteria required by the program to which they're transferring, but they go straight to the top of the list. So after the agency communicates with the coordination center, the coordination center will facilitate a referral to that participant to the next available unit through coordinated entry. So obviously the next unit for which they qualify. And for purposes of that emergency transfer, it's important to note that the household retains their original homeless or chronically homeless status. A few notes on VAWA protections on confidentiality. The threshold for confidentiality in emergency transfer requests is super, super high. So when a survivor submits an emergency transfer request, the staff that's receiving the request can absolutely not share any related information, including the mere fact that DV occurred, with anyone beyond the requirements of the law. And the requirements of the law are that the program keeps a record of the request and its outcome for 5 years and reports that to HUD every year. So besides the person that's receiving the request, and anyone else at the agency who absolutely must know in order to fulfill that obligation to report to HUD, no one must know about any details related to the emergency transfer. So this includes the landlord and coordination center. Neither the landlord nor the coordination center have a right to know any details about the emergency transfer. They can only know that an emergency transfer request has been made, and they shouldn't be told that it's related to domestic violence. So VAWA has these super strict confidentiality measures in place to really protect survivors from domestic violence reoccurring. And a little bit more on confidentiality. The program has to ensure that there are strict measures in place to prevent disclosure of the client's new unit to someone who committed or threatened to commit an act of domestic violence. Bifurcating leases. So to bifurcate a lease means to divide a lease to remove certain tenants, to evict certain tenants, and to allow the remaining tenants to continue to reside in the unit under the same lease requirements. So basically, it's possible to split a lease to remove a DV perpetrator and enable a DV survivor to stay. And the next steps really depend on the type of housing assistance they're receiving and where they're at with the lease. So basically, if DV occurs, the program can evict, remove, or terminate assistance to the household member who engages in the criminal activity without penalizing the survivor. And in this case, for tenant-based rental assistance and any utility assistance, that will all continue for the family members that are not evicted or removed. And in terms of eligibility, a few things to know are that in permanent supportive housing, if the family's eligibility was based on the evicted or removed member's disability or chronic status, then the remaining family members can stay in the project through the end of the lease. And this is good news if the family is still in their first year of the lease, but if it's month to month at this point, then it's potentially a much shorter time frame, maybe weeks or even days. And the family should definitely consider requesting an emergency transfer. For non-tenant-based rental assistance, these participants, if they haven't already established independent program eligibility, so say again, the removed household member is the one that made the household eligible, then the remaining participants have 90 days to establish their independent eligibility or locate other housing. And this is all listed in the Way Home for Tulsa Services Standards at page 90. Finally, we want to get into just a few of the limitations of VAWA protections. So we talked a little bit about all the reasons for which survivors can't be evicted or can't be terminated for programs, but it's important to note that a program participant, including a survivor, can be terminated or evicted for any violation that's not based on an act of domestic violence. And here what's important to note is that the program can't subject a survivor to a more demanding standard than other tenants or participants. So the survivor has to be subjected to the same standard as others in determining whether to evict or terminate assistance. And the program can terminate or evict a client if the housing provider can demonstrate an actual or imminent threat to other tenants, employees, or service providers. And the super important thing to note here is that this can't be predicated on stereotypes, and the determination of what's an actual and imminent threat has to be tailored to the particularized concern about the individual residents. And basically, you have to look at the duration of the risk, the nature and severity of the potential harm that would occur, the likelihood that the harm would occur, and the length of time before the potential harm would occur. And if you undertake this evaluation of these four factors, then an actual and imminent threat would be one where a physical danger is real and would occur within an immediate time frame and could result in death or serious bodily harm. Only such an actual and imminent threat would warrant terminating or evicting a tenant. So what are the things that a program should do before resorting to eviction or termination? There are a few measures that should be taken to ensure that eviction or termination are only occurring as a last resort. So the program should consider transferring the survivor to a different unit, or barring the perpetrator from the property, or contacting law enforcement to increase police presence or to develop other plans to keep the property safe. Also should consider seeking other legal remedies to prevent the perpetrator from acting on the threat. So all of these things should be considered to reduce or eliminate the threat before the program moves to terminate assistance or evict the tenant. And that brings us to a close. So if folks have any questions, you can always feel free to email Homebase at awayhomefortulsa@homebasecc.org. And again, that's AWH4T at homebasecc.org. And we're happy to answer any questions that you have about these VAWA requirements, and also to provide the template forms that I indicated. That's a template of the lease addendum that would help programs comply with VAWA contract requirements, templates of the notice of occupancy rights, and templates of the certifications that are required to be provided to participants at those 4 different points in time. So feel free to email us for those anytime, and thank you for tuning in.